All of the details that would be involved in the smooth actual administration and handling of the case, those are things that the attorneys need to discuss in the first meeting so they're really on the same page and they feel more comfortable with each other, because they need to mirror that cooperation and comfort to their clients when they're all together. Of course, they then share the basic data relating to their clients. They discuss the key issues in the case that they've learned so far, what their clients are prioritizing, if there are any special or urgent considerations that need to be addressed up front. Certainly the attorneys would discuss that. They confirm that both of the parties have received the participation agreement and that they have reviewed that with their attorneys and feel comfortable that their clients understand it and are willing to commit to that. Next, the attorneys need to discuss who else is going to join the team, whether this case is appropriate for having a coach participate, possibly two coaches, possibly each spouse might need their own coach for support. It depends on the dynamics of the parties in the case. And they talk about the financial aspects and whether having a financial neutral would be appropriate and needed in the case. And if there are children involved, certainly they talk about the addition of a child's representative. They talk about what professionals would join and then who in their data list of collaboratively trained professionals in those various teams they think would be a good match, depending on the dynamic and personalities of the clients. They set the agenda for the first meeting, for the first four-way meeting. They talk about the location, time, date, and it's as simple as who's going to bring the cookies and refreshments to make sure the clients feel comfortable. They discuss use of flow charts and flip charts or whiteboards and how they're going to really run the meeting. So those are the major issues that are discussed just between the attorneys before the first meeting ever occurs. What follows then would be the first group meeting, because again, collaborative divorce works through a series of group meetings supported by the professionals. In the first group meeting, everyone is introduced to everyone on the team. The main principles of the participation agreement are reviewed with everybody there so everybody can see and feel comfortable that everybody's on board and committed. The attorneys might briefly discuss with their clients why they chose the collaborative process and identify any concerns or fears they might have about the process. This is valuable, although it would have been and should have been discussed privately between the attorney and the client, but it's valuable to do that in an open session so that the other spouse can hear what their spouse is saying about the process. And that can build some trust, some confidence, or to the extent the other spouse shares similar fears and concerns, it might be comforting to know that that's a common concern that would be addressed. Then at the group meeting, the first group meeting, the attorneys would generate a list of tasks to be performed and who will perform them. And those would be the basic things that are involved in any divorce. It's gathering financial information, preparing budgets, forms as to assets, cash flow, identifying who's going to gather and produce that information. If there's any information relating to children, education, childcare that needs to be addressed. Again, all of the information that is needed, we would put that in a task list and assign tasks to the parties. If there are any immediate and pressing concerns, of course, those would need to be addressed. With that, after that is all discussed comprehensively, a time is set for the next meeting. The next meeting really is an information gathering and exchange meeting. Hopefully all of the information that was identified in the first meeting was actually collected. So then at the next meeting, that information would be exchanged and assessed. We'd be looking at values of assets, such as real estate, retirement accounts, business and tangible property. We would be looking at cash flow, income and expenses. If there's health information or special issues relating to the children, that's when all that information would be generated and produced and discussed. And the next series of meetings would really be working with that information. After that comes meetings relating to planning and solutions. There are two major agreements involved in divorce: a parenting agreement and a marital settlement agreement. So after the information and collecting phase and processing that information and making sure everybody really is on board and understands and is supported through that education and understanding process through the experts that are part of the team starts working on negotiating and working out settlements in the various areas of the case. And relating to assets, that would be allocation of assets, allocation of debt, addressing any support for the spouse or child support, that might be an issue, and looking at tax issues. When it comes to the parenting agreement, if there are children, again, we're looking at custody, visitation, holidays, vacations, health, education, and religion. And all those topics are addressed, negotiated, and worked out. In general, meetings flow with an agenda. The agenda should be set prior to every meeting so that everybody's on board and knows exactly what to expect at every meeting. And that should be distributed to all parties in advance of the meeting. Also, after every meeting is concluded, somebody is usually tasked with writing the minutes and the notes of the meeting. And then that's distributed to all parties. Again, that's important to capture in writing what everybody had discussed, and to the extent any advancement in negotiations had been made and any agreements had been reached with relating to any specific issues of the case, those should be memorialized in writing in the form of minutes of the meeting quickly so that everybody's on board and everybody's memory remains fresh, and then that could be a reference point for the next meeting so there's no dispute about who promised what or who said what. So that's a very important part of running successful meetings. During the meetings, modeling positive behavior is critical, and the hope is the parties will follow the positive behavior that's modeled by the professionals. And again, that includes interest-based negotiation and complete transparency. Working cooperatively to obtain and share information is a must to a successful collaborative case, and that is behavior that should be modeled to the clients. Which isn't to say that it's going to be easy. Attorneys should expect to handle emotional issues. Hopefully there'll be a coach there to support that, but attorneys would also be involved. And it's important to be skilled in addressing and refocusing conversations back to agenda items and not to let emotional issues derail a conversation. Again, with properly trained professionals, that usually can be done successfully. The meeting should typically identify long and short-term goals and move towards discussion of those goals. After agreement is reached on all critical issues, the next phase is drafting and revising documents, which would be the marital settlement agreement and the parenting agreement, to make sure that the documents reflect all the agreements. And of course, those are reviewed by both counsel and ultimately, hopefully, signed by the parties. And that concludes the collaborative process. At that point, an attorney would file an appearance, get a proof update, and the attorneys would appear, prove up the judgment, and the judgment would be entered. That would conclude the case. Finally, I'd like to just highlight some case examples and case history to really try to illustrate how the collaborative process works in various examples. The first example I'd like to talk about is a case that shows how collaborative divorce promotes creative problem solving. One of the many benefits of collaborative divorce is that the settlement is really finely tuned for the clients and their families. As I said, the clients are architects of the settlement, but they're supported in the process by the collaborative professionals. So unlike traditional litigation, where a judge might impose a more formulaic solution or settlement, in collaborative, there really is much more room to be precise, specific, and creative to the case, and in that way create an outcome that resolves in optimizing the settlement for both parties. So I want to highlight an example of how that worked in one particular case. I had a case where it was a high net worth couple, and they agreed that one spouse would receive maintenance for a period of time, and the spouse wanted to insure the maintenance payments, and as part of that insurance, she wanted the paying spouse to have life insurance. Make sure that in case something happened to the paying spouse, that she was covered as a beneficiary under the life insurance so that her payment stream would be secure. When we negotiated the settlement, the maintenance amount, it didn't contemplate very high payments for insurance, and it was then uncovered that the paying spouse had some serious health issues that made the life insurance quite expensive. And there was a lot of conflict about who would pay the life insurance. My client didn't want to pay it because he thought it was enough just that he was paying the maintenance, and if she wanted it, she could pay for it. And we were just at loggerheads. But we came up with something a little bit creative. Because they happened to be a high net worth couple, and there were a lot of assets that were available, we figured out that we could have an annuity. That an annuity could be funded with the full amount of the maintenance obligations over the period of time that they agreed to, and that the annuity would start paying the payments rather than having the spouse make the payments. And therefore, no matter what happened to the spouse, the payments would be secure, and that alleviated the need for the life insurance policy. The receiving spouse was thrilled because her payments were locked in and essentially guaranteed. The paying spouse was thrilled because it was much more cost effective, and we were able to reach a solution that made both parties happy and optimized the resolution for both parties. In a traditional litigated case, most likely a judge would have just simply ordered the life insurance, and that would have been the end of it. So collaborative divorce really does allow for a little bit more creativity. I would like to now turn our attention to talking about the role of other team members. Through the course of these discussions so far, I've emphasized that collaborative divorce is a collaboration of not just the parties, but a group of professionals in various disciplines. I've talked about what a collaborative attorney looks like and what the role of the collaborative attorney is. But other professionals are critical to the success of a collaborative divorce and the collaborative team. So now I'd like to talk about these other professionals and how they contribute. All the professionals on a collaborative team should be collaboratively trained and members of a collaborative organization such as the Collaborative Law Institute of Illinois, the International Academy of Collaborative Professionals. That training really is critical because they're not functioning in their traditional roles. They're using their expertise, but they're using their expertise finely tailored to facilitate the collaborative process. But the reason that's helpful is really it's meant to be a holistic process with the understanding that the separation of a family and the process of divorce is much greater than just the law and really requires a comprehensive team. The other benefit of using collaboratively trained professionals is that it levels the playing field. It achieves neutrality and cost effectiveness because only one set of experts is used, whether it comes to children's representatives and recommendations relating to parenting, visitation schedules, and custody. Having one child's expert versus more than one involved certainly could be less confusing for the child and much more cost-effective and less stressful for the family. Similarly, using a financial neutral one instead of two financial experts when it comes to evaluating options for a financial settlement, again, it's more cost-effective and promotes and models teamwork and neutrality, focusing on the common purpose of achieving the best result for the family, rather than having two experts, which becomes a very positional and polarizing process, not facilitating a positive, amicable resolution. So first I'd like to talk about the role of the coach. The coach is a mental health professional. It could, he or she could be a psychologist or a licensed social worker. The Collaborative Law Institute of Illinois describes carefully what credentialing is required in the mental health field in order to be a candidate to be a collaborative coach in a collaborative divorce. The coach does not work as a couples therapist. The coach doesn't really function as a therapist. The coach is there to facilitate the process. The coach has a specific function, which is to help the couple stay engaged and stay focused on the collaborative process. The coach works to facilitate positive and healthy communication and tries to assist in decreasing the couple's stress and anxiety. The coach can interact and speak to the couple's therapist if they have a couple's therapist, or if they're each in individual therapy with all appropriate releases that are signed. It can often be very helpful and positive for the divorce coach to educate any other therapists that are involved about the process and what the coach's role is in the process and what the role is not. And they could work together with the therapist to really become much more comprehensive in the support structure that the couple receives. The coach is there at the meetings to assist in ensuring that the meetings move forward productively and positively by trying to keep the couple focused and on track, talking about the goals and interests and the agenda items that are part of that particular meeting. The coach also assists in trust building to a sufficient level that the parties can maintain their relationship as divorced parents and to continue to communicate and co-parent. Next, I'd like to talk about the role of the child specialist. I would recommend that any time children are involved in a divorce, that a child specialist, let me start by saying a child specialist is a mental health professional that specifically focus their practice in children's issues. And again, the kind of credentialing and expertise that's required for a mental health professional to serve as a child specialist in a collaborative divorce, all of that again is laid out on the website of the Collaborative Law Institute of Illinois. But I would recommend that any case involving children also include a child specialist. The child specialist gives the child a voice in the divorce process. The specialist addresses the child's anxiety and uncertainty about the process and helps guide the child through what could and would happen in a divorce. The child specialist provides critical support and comfort for the child, and importantly, expresses the child's concerns to the parents in a way that the parents can hopefully understand and address any concerns and anxieties that their child or children may have. The child specialist also really helps coach the parents to develop parenting skills through a divorce, to the extent the parents are lacking the ability to really help manage and navigate their children through the divorce process. The child specialist really focuses on making sure that the parents have all the information they need about their child to make the best decisions they can for the child or children. And importantly, the child's representative really is the facilitator in crafting a parenting agreement, really working out a parenting schedule, a visitation schedule, a holiday schedule that doesn't just focus on what the parents hope to see, but really addresses and highlights what would work best for their child or children. Next, I'd like to talk about the role of the financial neutral. Also, anytime there's anything but really simple finances where the parties are just W-2 employees and have, a house and a retirement account, anytime it gets more complicated than that, or even when it's just that, it can be very helpful to have a financial neutral on the team. The financial neutral takes the work away from the attorneys of gathering the financial data and processing the data. So it's more efficient and economical for the parties to have a financial neutral because it's one person billing and spending their time to evaluate all the financial data versus paying 2 attorneys to do the exact same thing. Again, the financial neutral gathers the financial data and prepares a cash flow analysis. The financial neutral, again, also has gone through collaborative training and would be a member of the appropriate collaborative organizations, meets with the clients, and also works to educate the clients about the financial consequences of various possible settlements and generates options of various settlements for the clients to consider. Very critical. A very critical part of what the financial neutral does that can be enormously helpful in the case is managing the financial expectations of the clients. When each attorney tells the clients about when each attorney discusses the financial goals of the clients and helps their client understand what might be options in terms of financial settlements, it's not the same as having one exact person telling both spouses the exact same thing. And it can be very powerful to have one neutral sharing options and explaining consequences and managing expectations for both parties instead of each party hearing something similar but slightly different, each from their own attorneys. And that's a very helpful and critical function that a financial neutral plays. Of course, the neutral assists clients with developing a budget for separate households, identifies and evaluates tax consequences of different settlement options, illustrates some long-term financial objectives, very importantly, creates options